The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court. Now sitting.
Please be seated. Good morning and welcome to the Kansas Supreme Court. We are pleased today to have counsel and others with us as we hear the cases that are set on today's docket. For those who may not be familiar with the court's process, as an appellate court, we have reviewed the proceedings that have occurred in the district court, the arguments that the attorneys have made on behalf of their clients about those proceedings, issues that are raised for our review. As to the first case, we have a case that has come to us through the Court of Appeals, and we have reviewed the Court of Appeals decisions and the briefing that was presented to that court as well. We are thus pretty familiar with the facts of the case, as well as the legal arguments before the arguments start, but look forward to probing deeper into those issues as we talk to counsel and ask them some questions. So with that, I will ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call the 9 a.m. docket.
Thank you. First case on the 9 a.m. docket for Wednesday, November 1st, 2023 is appeal number 124236, State of Kansas versus Marlon Andrew Ford, Sedgwick County, briefs both sides.
It please the court, Kai Mann of the Appellate Defender Office. I'm here on behalf of the appellant Marlon Ford. May I please request 3 minutes for rebuttal?
3 minutes is granted.
Thank you, Your Honor.
May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas, appellee and conditional cross appellant, present and ready for argument.
Second case is appeal number 124471, State of Kansas versus Devontra Leonard Alston, Shawnee County, briefs both sides.
I'm Michelle Davis. I'm appearing on behalf of the appellant in the case, Mr. Alston. Morning, may it please the court. The state appears by Deputy District Attorney Jody Litfin, present and ready for argument.
Your Honor, that concludes our 9 a.m. docket.
Thank you, Mr. Shima, and thank you to counsel. That I would ask the attorneys in 124236, State of Kansas versus Ford, to please come forward.
Good morning, Your Honors, and may it please the court, Kai Mann of the Appellate Defender's Office on behalf of the appellant Marlon Ford. I know I just said, but just to confirm, may I please have 3 minutes for rebuttal? Thank you very much.
Yes. Always good to make sure, right?
Well, I will say, actually, on my first trip at this court, I forgot to ask, and I certainly didn't get it, so I'm pretty sure every other time. May it please the court. Marlon's Ford conviction is the result of a jury making a decision on a vague statute without the whole law following a highly objectionable closing argument. These conditions demand reversal individually and cumulatively. Mr. Ford's conviction of rape is reversible because the prosecution erred in closing argument, because the district court failed to instruct the jury fully regarding the law on rape, and because the Kansas rape statute is unconstitutionally vague. Now, I'm prepared to discuss each and every one of these issues, but I would like to start with prosecutorial error unless this court has any objections. The state in this case They took the concept of force necessary to be convicted of a rape and stretched it beyond any sort of recognizable bound in this case. The state told the jury that Mr. Ford was exercising force when he was driving from Kansas City, Kansas down to Wichita, exercising force from nearly another state line, exercising force again while he was calling her while she was in a locked building to let him up. Again, exercising force by a mere phone call when she's in a locked building, guarded by people on patrol to not let bad things happen, not forcible. And furthermore, and even more egregiously, the state told the jury that he continues to exert force when he asks if they can have sex. When we're dealing with rape, and when non-consent is an element of one of those of that crime, how can asking somebody for consent to avoid rape and to avoid, you know, any sort of negative sexual practice be an exercise of force? It just doesn't make sense. And this just stretches the element of force beyond any reasonable and recognizable definition. Now, the reason the prosecution felt that they could do this is because the Kansas appellate courts have never, ever tried to even attempt to put any sort of limit on what force is. Instead, in Borthwick, this court has just said, and this has been carried forward throughout, that the amount of force required to sustain a rape is highly subjective, and it can't be given it any sort of reason. In fact, you know, the full quote, I have it here. The force required to sustain a rape conviction in this state does not require that the rape victim resist to the point of becoming a victim of other crimes, such as battery or aggravated assault. KSA 3502 does not require the state to prove that a rape victim told the offender she did not consent, physically resisted the offender, and then endured sexual intercourse against her will. It does not require that a victim be physically overcome by force in the form of beating or physical restraint. It requires only a finding that she did not give consent and the victim was overcome by force or fear facilitating the sexual intercourse. That last sentence is correct, but what this case shows is that there has to be some limit to the term force. Again, the state is claiming Mr. Ford was exercising force from essentially the Missouri state line. I'm sure he ate breakfast that morning. Those calories are fueling him. Was that now a forcible breakfast because he was going to go down there that night? The state essentially, they try to find a point where they can pick and see a force. And then
I have two questions. I'm so sorry to interrupt. The first question is, would you agree in Kansas that the law, and for some reason I don't have the case that you cited, but State v. Tully and State v. Cheney, that force in the context of rape is a highly subjective concept that does not lend itself to definition as a matter of law, and whether a victim is overcome by force is a finding only the jury is entitled to make. That's the current status of the law in Kansas, correct?
correct.
Okay. And then the next thing is, and I understand that in the closing argument that is exactly what the prosecutor argued about, you know, the force started when he left Kansas City, calling her, but the prosecutor later argued that the defendant, within the same discussion, that the defendant used force by pinning her arms down, lifting her shirt, pressing her face, pulling her pants down, and other restricting movements. So read in context, when you're looking at all of it, would you agree that the prosecutor's statements didn't improperly attempt to define force?
No, Your Honor, I wouldn't. I would say that those comments focusing on, you know, the allegations of the pinning and the forcing of the legs and those things, clearly force. But where the prosecutor, and again, the prosecutor could have stopped there. It's not like they didn't have any evidence of force and they were trying to face it. This is a he said, she said evidence provides a lot of force. But where the prosecutor erred is that just wasn't good enough for him. They had to find this force goes all the way back to Kansas City, goes all the way back. And that's how the jury gets confused. And as we saw, the jury was clearly confused in this case. They asked for a statutory definition of rape. They asked for a readback of both parties, and they announced a split verdict. So had the state just actually stuck with what force is and not tried to drag the force element back several hours to where they were hundreds of miles apart from each other, then they might have an argument for a clean conviction. But making this argument, that just takes every other force element out, because what the state did is that said, well, there's force down here. So everything leading up during that day is force. And that's just silly. And that just can't be the way. And if that is true, and if this is true in context, then I think we get into a huge vagueness problem, because if force truly is so subjective and so individualized that we cannot give a standard and it's only for juries, how is that not failing to apply an explicit
Well,
standard?
let
of
me say,
enforcement?
is force just defined in the, or confined to physical force? Why can't there be psychological force?
I think there can.
Which could certainly start in Kansas City, driving to Wichita with the phone contact.
But-
Why can't that be a part of the whole nature of force?
Because it's also forced to overcome the victim. And I don't see how anybody calling repeatedly from a locked building with staff to not allow visitors and unwanted people to come up, how that can be forced to overcome. And furthermore, when we look at the definition of force, if we take the force as, argued by the state or in the closing argument, and we look to the force with their subsection E argument, I'm kind of mixing these two together, but we have a situation here where the force and the fear can be wholly personal to the victim, not emanating from the defendant and known to nobody else but the victim.
But counsel, you just said that force is individualized with the victim.
No,
Correct?
that is our current state law. I think we should be looking at force from a reasonable perspective, not from whether this person claims they have force and we can't do anything about it because it's so subjective, but whether a reasonable person in this situation would find some sort of force.
Isn't force always going to be a matter of individualized context?
I mean, yes, but words also have meaning. And if we look to the dictionary definitions of force I cited in my brief, they all talk about power, violence, strength. Even if we look to our definition of forcible felony in Kansas under 215111N, that defines forcible felony as any felony involving the use or the threat or use or threat of physical force or violence. So I think unless there is an actual something coming from the defendant that there is going to be a negative outcome, that there is going to be some harm, again, be it psychological, be it financial, be it physical. But where we have the situation now is that between the subsection E and the way the state is arguing force, is that force can be anything as long as it's connected to something that they claim is a.
So is it your position then that force only should take into consideration the context of what the defendant is doing and not of its effect on the person that he's having sex with?
No, I think it needs to take into account both. Where we're at now is that a defendant could give somebody a present, right? And somebody could say, oh, I feel the need to have intercourse with this person. I don't want to, but they gave me a present. I have no idea. No, I did a nice act. I gave a present. But under subsection E and the way that the state is arguing force in this case, that can become rape. What I'm saying is that the force has to be known to both parties. It can't be something that a defendant, and again, I know that this isn't my case, but the case that's on the unpublished calendar, NIN, from my reading of that case, the force or fear was wholly come to and imagined up by the victim. And if that's the case, if there's nothing that the defendant does to put that force or fear, that aura out there, then I don't say how we can, I just don't know how that survives vagueness and turns every sexual encounter in the state into a very, very fraught proposition.
But the state has the burden to prove the force or fear, right?
Right.
Okay, so when you're cross-examining the witness, you don't say, did you feel force or fear? Yes. I mean, a jury is going to be like, that's not evidence. I mean, they're going to have to go into what did you, what was the force or fear?
Right. No, and again, and that's fine. And in this case.
So isn't it implicit within that? Like, well, I was fearful that, I mean, if it's some ridiculous thing, I mean, isn't the reasonableness kind of implicit within that?
If force is phone calls, if force is asking for consent and that's good enough, then no. Then that's why this is prosecutorial error, because any sort of reasonable bounds and conceptualization of force was just ran right over like a Mack truck by this state.
But you're really focusing on, these couple of sentences, but the prosecutor argued the force was pinning the arms, lifting the shirt, pressing his face into hers, pulling her pants down, and all these other restrictive movements. So is this just not the right case for you to make that argument? Because
Absolutely not, because the state could have focused their force argument on force. But what the state did is they took force and they said that everything that coming before that is actually force. So whether or not you believe him, if you believe Mr. Ford about what happened in that room, they could still convict him by finding he forcibly drove, by finding that he forcibly asked him for consent, by finding that he forcibly, again, drove. No, because had the thing been limited, then we have a credibility determination and my client is found not guilty.
I'm having trouble figuring out which analytical silo to put the arguments into, and maybe they fit into two. But are you arguing that the prosecutor misstated the law by making this argument? Or are you arguing that the prosecutor drew unreasonable inferences from the evidence?
I'm arguing that it's both. I've explicitly briefed it that the prosecution misstated the law regarding force. My secondary argument, if what they said is fine, then we've got an unconstitutionally vague statute because nobody can protect themselves from force there. However, if they are drawing inferences that are impermissible, then that is equally prosecutorial error. But in my mind, if what the prosecutor said in closing argument, we've got a major statutory problem that is going to ensnare a lot of people in a very serious level of crime.
And is that true when we think about our broader context of criminal law? Of essentially the perpetrator takes the victim as they find them. If that perpetrator puts into motion a chain of events that has a causation that would lead to psychological force, why is that not consistent with a lot of other principles of criminal liability? Because there is no principle of psychological force here. Simply driving down is not force enough, especially when you're in a place that is locked with staff to prevent people up there.
What if in each of the instances that you object to, the prosecutor had used the word fear instead of force?
Then I still think that is stretching this beyond any recognizable. Basically, the state is having it to where
Why?
because there has to be some way a person can engage in sexual intercourse with knowledge that they are not performing rape. And under the argument of the state, combined with their interpretation of subsection E in the new statute, that just can't happen. I could ask somebody out for a date, somebody could ask me up, but they could say, hey, in their head, they could be thinking, I really don't want to have sexual intercourse, but I like this person. And I'm afraid that if I do not have sexual intercourse with them, I'll never see them again. And we go through sexual intercourse, they consent. Have I committed rape? Under the state's theories, I have. And I just think that is wildly, wildly dangerous. And this court should not let that stand. And I see I'm out of time. I have no more remarks, but I'll answer any questions. Thank you.
Gillette?
May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas. I'll focus the majority of my time today on the prosecutorial error issues as well, unless this court has other questions. I will also definitely mention my conditional cross appeal in this case. Respectfully, I think the last hypothetical that was just articulated proves that defendant's argument fails because what he described was a scenario in which the person doesn't want to have sex, but really likes him, but then chooses to consent. And that's the key here. Sexual intercourse is a uniquely intimate act, and consent must be present at all times from all parties participating in that act. It is that simple. That is what the statute provides for. Effectively, that's what KSA, our rape statute subsection E makes absolutely clear. We are not playing the games from Bunyard and Flynn anymore. Our legislature has made that clear. Properly viewed in context here, the prosecutor's arguments regarding force or fear were all appropriate.
So I take it you agree with the way the Court of Appeals resolved this,
Absolutely.
when they said the prosecutor's use of the word force is not a statutory use of the word. And I just wonder if you think that really holds water. I mean, the jury was instructed on force.
Correct.
And the statute uses the word force.
Correct.
So it strikes me as, I'll use the word problematic for the prosecutor to repeatedly use the word force and then just say, well, I wasn't talking about the law.
I think we have to look at, again, we have to understand the context here, and the word force is not defined in statute. It is defined in our case law. It's as opposing counsel.
Would you, I guess, just practically common sense question, wouldn't, if you, or we imagine a reasonable person sitting in the jury box, why wouldn't they think that the prosecutor was talking about the force that I've just been instructed on, the force that's reflected in the statute?
Because we have to understand the context. And what we start with here is we're talking about where the defendant began his force. She's not explicitly tying that to the actual act of rape, what made defendant guilty of the crime of rape. She was describing a constant escalation of force, the psychological force, which I believe opposing counsel has even agreed can be a form of force. This began with manipulation. It continued to a point where he put her in an impossible situation. Opposing counsel wants to talk about a locked building, et cetera, but what is the victim going to do when a friend of multiple years is telling her, I'm going to freeze out here in my car? She lets him in. There's refusing consent. He asks the question, are we fucking? And she said, absolutely not. That's not what's going to happen. It proceeds. She falls asleep. She's tried to help a friend and wakes up with him physically raping her on top. That's what the prosecutor's comments were all taken in context. And I guess the additional thing that I want to point out.
Well, and let me just read you one line. The prosecutor says that the defendant's force did not start in the victim's bedroom. The force started when he left the Kansas City area against her wishes. That's him exerting force over her decision-making ability. I mean, is that a correct statement of the law of rape?
Again, I don't think that in context, she's trying to state the law in regards to rape. She is tying.
That's what you have to hang your hat on in this argument, is that we should not read that as a statement of law. That kind of circles back to my original question, which is, isn't that exactly how the jury would have understood it?
I don't think that that's how the jury would have understood it. I would think the jury would have understood it because she tied it expressly to the facts that that's what she was talking about. She's not trying to make a definite statement of law. And the reason for that is because rape is subjective, as we all agree here. Each individual will have a different threshold for what constitutes force or fear. That's all the prosecutor is talking about here. We have a particularly vulnerable victim based on the way that the defendant set this up, pressured her over the span of 2 days, and then proceeded to, as two things, as starts doing this to obtain his objective by any means. And that's what the prosecutor was talking about here. And then, as was pointed out several times, this does escalate to the physical force that is actually applied in the bedroom here. I guess I would also note that properly viewed in context, these arguments about force also directly touched on credibility and that this defendant's intent to obtain his objective by any force. So I don't think it is fair to characterize this as a statement of law. It certainly is not akin to, as opposing counsel has briefed, trying to define reasonable doubt. She's not trying to define force. She's saying this: the facts of this case show that force was applied, beginning with manipulation and pressure and escalating to physical force. There's nothing wrong with that. I would note it's also, I think, respectfully, I think it's telling that.
I mean, factually, I understand that argument, but legally, is there a temporal or some sort of limitation when you then dump it into the actual instructional language or the language of the statute?
I think.
Or is our appellate authority that it's just an undefinable factual question?
I would begin with, it is an undefinable factual question. I don't think this court should delve into telling individuals what may or may not constitute force for them, because it is so highly subjective. There is a world of difference amongst individuals in this state, and we simply cannot craft a singular definition that would define force for every single individual. And then to your second question regarding the temporal nature, I think that the correct way to answer that is it depends on the facts of the case. I'll briefly touch on Nin. It was an unpublished case that I know that this court accepted the petition for review on. Neither party has filed any kind of a supplemental notice about that, but I know it's on this court's summary docket today. It, I think, is an example that is distinguishable from this case in two ways. First, in Nin, factually, what was talked about there were events that occurred over years. And the initiation there wasn't necessarily any indication of actual pressure. It was quote unquote grooming, touching, something that may not have been understood by the victim at that time, but that was not necessarily even psychological force because it was not understood. It's also, I think, legally distinguishable because when we talk about grooming, it can constitute a number of different things, many of which would not constitute force, as I said, something that may not be understood at all. So I think that's an example that I think would answer your question as far as the temporal connection. If there are no other questions regarding that, I think it's also worth noting that what we see here is that the state has tried to put the argument in the best context it can based on what a jury would have understood and what's seen here. And what we have on the contrary is a defendant in his second or third argument about prosecutorial error, claimed that the state argued, quote, the only force necessary for rape is the act of intercourse itself. Those words don't appear anywhere in this. Quite to the contrary, this case is highly distinguishable from that kind of an argument that occurred in Bunyard. I think that's telling of what we have here. We have what a jury would have seen in this case versus what a defendant would like this court to see after the fact based on a subjective interpretation that may or may not be actually even linked to the record.
Can you speak to your cross appeal?
Sure.
I'm interested in that, and I guess kind of lay out, is this case even I know you say a modified Bunyard instruction is no longer applicable given the current state of and the amendment to the rape law, but even if is it factually appropriate in this case, in those distinguishing Bunyard and the other case to this case, is that there was consensual sexual activity between the two. Here, there really either was or there wasn't. There isn't an agreement that there was consensual activity on the part of the victim in this case. Does that make a difference here?
I think it does to a certain extent, but I'll explain why I think that this court can and should take the opportunity to address the legal question.
Yeah, I'm thinking factually, why does it even fit? But go ahead.
Sure. So to be clear, a modified Bunyard instruction provided that rape may occur even though consent was given to the initial penetration, only if that consent is withdrawn, that withdrawal is communicated to the defendant, and the sexual intercourse continues when the victim is overcome by force or fear. There's about 5 different things that have to go into that. But here, unfortunately, this instruction, it was not requested below. So it's not preserved. The defendant never even attempted to carry his burden to demonstrate clear error until a passing attempt in a reply brief and then in his petition. But no, to answer your question directly, no, it's not it wouldn't have been factually appropriate here.
That's where I'm kind of having trouble even getting to it. Mr. Mann can certainly address this too in his rebuttal, but it doesn't seem to fit.
So it's not factually appropriate because the victim was clear there was never consent and that there was force here. Even in the defendant's varied accounts, there's never a description of a factual scenario that would fit under Bunyard. I think that this court can and still should reach the question of whether or not it's legally appropriate, because that's the clear error rubric. We have to answer that question first. And respectfully, it's time we have an answer to that question. Bunyard opened a door that frankly would be that canon was terrifying for a number of individuals. It was vague. It was created by judicial fiat. Flynn tried to walk that back, but left open a number of vagaries and concerns that could have still left victims subject to additional force, harm, battery, etc. That's not required for a rape, but a defendant could still play dumb, essentially, or be more violent and then play dumb because he could try to benefit from that. He or she could try to benefit from that. But it's important here because in Flynn, this court drew the line that it would only apply to rapes prior to July 1st, that occurred prior to July 1st, 2011. Since that time, we've had KSA 215503E. It is about as clear as a statute can be. It shall not be a defense that the offender did not know or have reason to know that the victim did not consent to the sexual intercourse, that the victim was overcome by force or fear, or that the victim was unconscious or physically powerless. I would note that that does also make an exception. It doesn't apply to A2 where we're talking about certain types of rape. This language does apply to the law as charged in this case. And I think it is important to be clear that it would not have been legally appropriate, because it is also possible in certain cases where I guess one could try to argue, though not here, that it might have been factually appropriate and legally appropriate, or that it may have been factually warranted but not legally sound, vice versa. It's just a matter of needing clarity.
And on that point,
Yes.
I want to ask a pretty theoretical question about the statute itself. And I'm struggling to figure out, I know the way the statute's set up, it's easy to just read the statute and say, well, these are the elements of the crime. But are the subsections under A1, are they really elements? In other words, force or fear, or do they actually function as essentially statutorily mandated evidence of lack of consent?
They are elements.
So if they're elements, my follow-up question is, that would suggest that there is such a thing as non-consensual sexual intercourse in Kansas that is not rape. And is that right?
I might need a little bit of clarification, because the only circumstance in which I could see that would be under subsection A2, and it would require very unique evidence, and it would probably require evidence from a defendant themselves. That's not necessarily a burden shifting, so that's not accurate, but it would require very unique evidence about mental capacity or incapacitation due to some kind of a substance. That's the only realm I could see that in, where a defendant can still try to claim a lack of knowledge. The other elements, the other subsections, 1, 3, 4, 5, those you cannot try to claim a lack of knowledge or ignorance at this point.
They just it seems repetitive, I guess. I mean, if there's no consent, that's what I'm trying to figure out, is reading the statute. We have consent, lack of consent, obviously, that is the central, one of the two central elements of the crime.
Mm-hmm.
So what does being overcome by force or fear really add to the equation?
What is being over?
Other than evidence, it's evidence that there was no consent. It's really duplicative, though, of the lack of consent as a legal matter, isn't it?
I guess I'd start by saying, even if it is, I don't think it matters. But at the same time, I think what it's describing is there is this concept of consent. It is individualized, but then to overcome it, requires force or fear. That would require additional evidence specifically that that individual's threshold for consent was overcome. That's the best way I think that's the correct way to answer that question. I see I'm out of time. If there are any other questions, I would welcome them. And if not, I would just leave the court with the fact that force and fear is highly subjective, and we should stick to that. We should enforce that. That has been the law in Kansas for a very long time, and nothing's changed about people other than the fact that we now recognize more clearly that the individual's rights should matter.
So you have to prove lack of consent, and you have to prove lack of force, or you have to prove the existence of force
Correct.
that overcame consent.
Correct.
So if on cross-examination, a victim, and there's overwhelming evidence of lack of consent, but if on cross-examination, the victim answers questions from defense counsel to the effect of, no, I wasn't afraid. No, there was no force. Then that's not guilty as a matter of law.
It's not guilty as a matter of law, because that evidence would have to be tested based on the credibility of the victim. And
Okay, well, let's
let's
just assume the jury believes the victim. Then you're saying not guilty.
If the jury believed the victim in that circumstance, then
Jury
yes.
can believe that there was no consent, but it's still not a rape. I mean, you see what I'm sort of driving at.
I kind of see what you're driving at. But I think the answer is, I guess the answer to that would be no, because we have to prove that all these things exist at the same time.
That would mean it's an element. If it's an element, you have to prove it.
Correct.
Okay.
Yeah. And if there are no other questions, I appreciate this court's time. I would ask that the Court of Appeals ruling in this case be upheld with the exception of my conditional cross petition. Thank you all for your time.
May it please the court. I would like to start first. I know I've got a lot to cover, but as far as preservation of the modified Bunyard instruction, Flynn was a one-issue case. The only issue in that case was whether or not a Bunyard instruction kept going. So the fact that the district court discussed Flynn for 5-6 pages, and I can't argue Flynn and proper application on Flynn on appeal, that instruction is preserved, or there are major problems with our preservation precedent. Secondly, with factual appropriateness, the factual appropriateness of that instruction is triggered on the withdrawal of consent. So
Where was their withdrawal of consent?
in Mr. Ford's testimony, he
He
testified.
just said we stopped.
Yes.
Is that stopping is withdrawal of consent?
When she said stop and he stopped, that is withdrawal of consent. Yes, stop having sex with me is withdrawal of consent. That is the classic withdrawal of consent.
I thought the quote was ended abruptly.
His testimony, if you read his testimony, I don't have it up here right now, but his testimony is that we had consensual sexual intercourse for about half a minute to a minute. And when she said stop, I stopped and left. There are two stories in this case. A victim is not presumed credible, is not presumed to be telling the truth any more than anybody else. Mr. Ford deserves belief, and that's why this. That's why
I was looking at your client's testimony. I wasn't. Yeah.
Again, that's the way I read it. That's the way I read it. The instruction is triggered on the withdrawal of consent, because if they can find that he stopped at the withdrawal of consent and did not go further, they acquit him. That's why this is factually appropriate. That's why this is so key. The jury requested readbacks of both parties. This was not an
Why
easy
wouldn't
question.
they do the same thing under the instructions that were given?
Because they were obviously confused. They did not know statutory definition of rape, because the statutory definition of rape doesn't cover post-consent or post-penetration withdrawal of consent, as this court recognized in Bunyard and Flynn, why those instructions exist for the first place. And secondly, they asked for a definition. They were confused. They asked for readbacks showing that they were weighing this credibility and that they were initially split. Even if this is clear error, even if this is clear under Bergstresser, what more can somebody show that a jury was having problems with this, and that an accurate instruction informing them on the whole law of the subject would have returned an acquittal on a level 1 case on my client's only conviction?
Address Justice Stiegels.
Absolutely. Hypothetical. Person A threatens person B. I'm going to kill your children if you do not go have sex with person C. Person B does not want their children to die. goes and have sex with person C. Is person C guilty of rape, even though there was no, B did not truly consent? That consent was only by compulsion. Again, consent and force and fear are heavy. Sexual intercourse ranges from a lot of different factual scenarios, especially with young people. We need to be clear.
I
We
hate
need
to-
to protect everybody.
I hate to interrupt, but I think that's a different question. I think Justice Stiegel's question was, I didn't really consent, but I'm not afraid and I don't feel forced.
No, that would not be rape because there are 3 elements of rape.
If that's true, then isn't it isn't it evidence that is relevant and probative, thus material, if she says, no, don't come, and he says, I'm coming anyway? Isn't that evidence of, I don't care what you say, I'm going to do what I want? That's force, isn't it?
If we interpret the evidence this way, again, we're starting from his position that we're believing her, but he said, I was invited. He said, I've never been to Wichita.
Okay, but
And
does-
but the jury struggled with this. They had readbacks of both parties. If you read these testimonies individually and you believe her, you're not asking to read back for anything. So this was such a close case. We have an instruction that clearly covers this exact situation that is not negated by subsection E, because Mr. Ford's defense is I was unsure. His defense is there was no rape.
But-
This was consensual sex.
But can you answer my question though? Which is, and he said to himself, I don't care whether you want me to come or not, I'm coming anyway. Isn't that a mindset of force?
I can't agree with that because that's not what our record reflects with my client's testimony. If I were just going to believe what the victim were going to say, then I don't know what I would be doing here.
Can't the jury infer that?
They
Doesn't
can,
know
but the inferences we got on this record when they asked for a readback shows that it was a much closer than that. And that's why we need that extra instruction. And that's why the state's prosecutorial error was so harmful. Because they took the jury, who was very closely divided on a question of credibility, and the lack of instruction and the prosecutorial's closing error just destroyed anything. And just one last thing.
Well, I'd like to ask a question. Okay, so I want to get back to this legal appropriateness. So we know what the modified Bunyard instruction says.
Mhm.
And, it's consent is withdrawn. Okay, so that's already, the consent is already an element of the crime, so that's no big
Mhm.
deal. And then the third one is the sex continues when the victim is overcome by force or fear. That's already an element of the crime. But the B, the second one, withdrawal is communicated to the defendant.
Mhm.
Okay. Now, this directly conflicts with 215503E.
I disagree.
Because there is, E says that it's not a defense that the defendant know whether or not there's consent, right? Is that true?
The way I read that is that the defender did not know or have reason to know that the victim did not consent. Here, we have knowledge that they did consent.
No, I'm just talking.
I know, but in a Bunyard
No,
situation.
you don't know what I'm saying because I didn't finish my sentence,
Okay.
which is that not looking at the facts of this case. I'm just looking purely at the law and whether this is a legally appropriate instruction. Okay? That in order to give this instruction in a post-penetration case, withdrawal of consent is communicated to defendant. When we have subsection E that says it is not a defense that defendant know whether or not the victim consented. I don't understand why in a post-penetration case, number one, you're totally confusing the jury because you're giving both of those instructions. And then number two, why are we drawing a line there? Because the prosecutor has the burden to prove that there was no consent.
But in a post-penetration case, a person has consent and then they're having sexual intercourse.
But the prosecutor doesn't have to prove anything about.
I know.
Well, may I finish my sentence?
Yes.
Yes, thank you. But we're not focusing on the consent part because that's not the crime, right? So you could just ignore all that. I mean, what we're focusing on, what the prosecutor has to prove is no consent.
The prosecutor has to prove all the elements simultaneously. And if you have consent, but the other two, but then consent magically comes in, you have to prove that they all exist simultaneously per 51.7 or 5107F. Now, what happens here in a post-penetration case is that consent's taken care of. You have consent, or else it wouldn't be withdrawn. Now, this is why, if that is true, that if a person can give consent, withdraw that consent mentally and silently without ever saying anything, then that's why we have a vague statute, because that sets the stage for any person to have sexual intercourse and then later say, no, I changed my mind halfway through and I was scared halfway through.
Right, but the prosecutor would have to prove that. So let's talk about, how does a prosecutor prove that all of a sudden the victim's not consenting anymore?
By the victim saying, I told them to stop and they kept going, by Bunyard and
Right,
Flynn.
okay, I told him to stop and he kept going.
Yes. And
So implicit within that is now that the defendant knew, I mean, that is, it's communicated.
right.
Let's think about other ways.
But-
How else can the prosecutor, besides this communication?
I mean, like he talked about defendant trying to play dumb or force. If you're playing dumb, and this is even kind of, shouldn't even have to say this, but if you have to play dumb to not notice somebody's withdrawing consent, or you have to use violence to silence somebody, as they said in the brief, that's rape. There's not consent, or else you wouldn't be playing dumb, or else you wouldn't be using violence. Subsection E, read literally and strictly, as in your hypothetical, creates an incredibly vague statute by which anybody can be guilty of rape after any sexual intercourse.
No, because if you're there and you consent, and then all of a sudden you think, I don't want to do this anymore. And you don't communicate it, you don't push them off, you don't do anything. You've just changed your mind in your head. How is a prosecutor going to prove withdrawal of consent to a jury?
No, I think we might be talking about a couple of different things here, because I'm talking about a situation, consent is given, a victim withdraws their consent. A victim can just testify to that. I mean, there's no consentometer, there's no.
Right, but if I say, but if I'm the victim and I say,
Right,
I changed my mind and I didn't want to do it anymore.
say that,
Right.
Yeah.
Okay, but how?
by having the victim testify to that. And that's why this instruction is so key, is because these are credibility determinations, and you can't make.
Do you think a jury would convict on that?
Juries convict on things that I see all the time. I don't know. I really don't know. Like I said, we all like to pretend we know what juries do. And that's part of my problem with our current clear air analysis, because we don't. We really don't. And we just assume, pretending to know what juries would do, we just can't do. I can say what juries might do. I can say what one juror would be more likely to do than the other, which is why we need to wrap a probability standard back into Bergstresser and the clear air standard. But no, I honestly can't say what a jury do. All I know.
Okay, so let's just take it a little bit further. Okay. So if we make this rule for post penetration,
I mean,
okay, and I'm the victim, and I don't consent from the beginning, and so I go to a nurse, and and so I've had intercourse, and the prosecutor says, "Did you consent to this?" No, I never wanted to have sex. Did you communicate that? Did you push the person off? Did you do? No, but in my head, I did not consent. But I don't get that instruction, right? Because it's not post-penetration change my mind. Why would we differentiate between me not consenting from the beginning versus me changing my mind post-penetration?
Because if a person has sex with you without your consent, and they're committing rape, but if a person has consensual sex with you and then you withdraw consent, then that turns rape. It's a matter of consensual sex turning to rape as opposed to rape all the way through. That's the difference.
But if I say at the very beginning, I didn't consent, but I didn't communicate, I didn't do it, but but there's no instruction given at the beginning
No,
that.
No, but I mean, but the instruction is that, I mean, that's just the regular rape instruction. The victim did not consent. And in a post penetration.
But this second thing that says withdrawal is communicated to defendant. So withdrawal of consent is communicated to defendant. Why aren't we telling the jury in my hypothetical that from the beginning that my non-consent is communicated to the defendant? Why aren't we requiring that instruction be given, when at the beginning?
Because you can't withdraw something that's not given.
But let's take out the withdrawal. Because what we're basically doing is saying in that second thing, you have to communicate the fact that you're not consenting to the defendant.
Because you've already given consent. Because the status quo is consent. And if you got to change that, you've got to let somebody know that. That's why, because consent is in place, because you already have consent. That's why you have to communicate that, or else the defendant is going to know. And you don't have to verbally say it. You can try to push somebody off. You can make actions. I mean, I'm not saying it has to be like wave a red flag 3 times or fire up a flare. If the situation can turn where somebody reasonably knows that they don't no longer have consent, you have to go, but there has to be something, because that person is operating under the consent that they were given.
Okay, so final question, and I know I've gone way over your time. So you don't believe the fact that you have to communicate that to the defendant that you no longer consent, you don't find that to be in complete contradiction to subsection E, which says that it is not a defense that you didn't know that the victim didn't consent?
No, because in the withdrawal of consent cases, the defendant already has affirmative consent. They're possessing of consent.
But this is the plain language of the statute, right?
No, I know. And again, but I do not think that those are different, because that person was operating under the knowledge that they had consent. And unless something else goes on, they're going to continue to operate under that knowledge. They are having sex with somebody with a person who consented until that withdrawal is communicated. Because how else are they?
The legislature should do, or is this something you want us to do?
I think that unless this court interprets it that way, that then we have a vague statute, as I've argued in the vagueness section, to where every sort of intercourse is running the risk of, again, and not just a crime, one of the most serious crimes, carrying lifetime registration, level 1, like rape, big one.
Thank you so much for answering my questions.
I'm sorry, I got a little bit worked up. I think we're just talking past each other.
I don't think so. No, you answered my questions. I appreciate it.
Well, I've been way over time. I don't have anything prepared.
Thank you, Chief.
Thank you.
Thank you to both counsel for your arguments in this case. The court will take the matter under advisement, which means that later today, the court will discuss this case, and justice will be assigned to write an opinion for the court. That opinion will circulate and the discussions will continue until we have reached agreement or know that we have separate disagreements that will be represented in separate opinions of the court. The case will then be filed with the clerk of the appellate court. The information will be released by a press release, and that opinion will be available on the court's website at kscourts.org. Thank you, counsel, for your arguments. Now call forward the attorneys in case number 124471, State of Kansas versus Devontra Alston.
Mr. Alston appears by counsel Michelle Davis. May I please reserve 2 minutes for rebuttal?
2 minutes is granted.
Hopefully you can hear me okay.
Yes.
Okay, I probably shouldn't have messed with that. This is Mr. Alston's direct appeal from jury trial convictions for several crimes, including premeditated murder. Based on a shooting that Mr. Alston was not present at, the circumstances of the shooting is that one car is following another car and one car turns right. It's the driver ends up being deceased. The other car turns left and shots are fired out from the other car while the car's turning. that go through the back windshield, striking striking the deceased and killing him. The state's theory, so Mr. Alston wasn't present at the shooting. The state's theory was that it was Mr. Alston who procured the men to commit the shooting. And the defense in this case, the state's evidence, you can infer from the state's evidence basically that the deceased left the house belonging to Mr. Alston. And there were other people also present at the house. There was a gentleman by the name of, let's see if I can find. There was another gentleman at the house who was also involved with a woman who was involved with the deceased. Also present at the house were the woman and the other man. And the defense theory in this case is that the other man could have been the one who said, you know, he's here at the house, or he's leaving the house from which the other car followed. So that was the defense in this case. Defense counsel also raised the claim that the state, based on the state's evidence and based on the prosecution, that these conviction should only be for conspiracy to commit the premeditated murder and should not be for the actual premeditated murder or the discharge of a firearm at the vehicle. And again, Mr. Alston was convicted of those crimes, the premeditated and the discharge, based on a theory of aiding and abetting. And so the jury was instructed that Mr. Alston was liable for the conduct of another if he aided in the commission of the crime, or he advised, counseled, hired, or procured another person to commit the crime. And in closing argument, the prosecutor told the jury that Mr. Alston was guilty of premeditated murder because he had procured, which is one of the, what a jury needs to find in order to convict of aiding and abetting. So what counsel argued was that basically, with premeditation, you're saying Joe commits an intentional killing of a human being and is premeditated. If you want to also hold Sue responsible, you have to say Sue committed an intentional killing of a human being that was premeditated by procuring Joe to do so. Or another way of saying it would be that Joe committed an intentional killing and Sue procured Joe to do so. So in order to find someone guilty on a theory of aiding and abetting, you're really adding in another circumstance, another fact that needs to be found by the jury. And the other fact is basically that the person aiding and abetting has the mental state to commit the crime, and that they then commit an act in order to assist in that crime. So basically, aiding and abetting is a theory saying when you have a concerted effort by more than one person or a group of people to commit a crime, we're not going to distinguish between the principal and the aiders and abettors. They're all liable under our law. So it's on that theory that the state prosecuted Mr. Alston. The state also prosecuted for a conspiracy to commit premeditated murder. And that's what defense counsel said. This is a conspiracy case. That's what the state's basically alleging. And an overt act in furtherance of the conspiracy. And the state charged that the overt act was the killing itself. And that's what the jury was instructed on. And that not necessarily that one of the conspirators committed the killing. It didn't specify who. So Mr. Alston or another committed the killing. So the conspiracy is there was an agreement between Joe and Sue to commit an intentional murder that was premeditated, and Joe or Sue killed a human being. That's basically what the state had to show in order to prove conspiracy. And so counsel argued to the district court that those, basically two theories, that those are identical offenses because they're both requiring the same things for the state to prove. And also that the conspiracy was actually the more specific crime in this case, because that's basically what the state alleged. And I think the law is somewhat changed on this. I guess the underlying question here is how has the legislature defined the offense and legislative intent? And this court has used certain rules such as the Schoonover same elements test to try to discern what the legislative intent is. There was, at the time of Schoonover, the statute, which is 215109B, basically talked about you can be convicted of the crime charged or a lesser included crime defined as a lesser degree of the same crime, or when the lesser contains all elements that are in some of the elements of the greater. That was the test. With the recodification in 2011, the legislature added in 2 other provisions, and basically it brought in a provision, this is subsection D, that is basically the specific general doctrine that this court was a court doctrine for years. Well, it's now in the statute, and basically said it's when crimes differ in that one prohibits the conduct generally and the other prohibits a specific instance of that conduct. You can't convict of both, and you have to be sentenced with the more specific. And this is what counsel argued below. And then the subsection E is the identical offense. You cannot convict of identical offenses based on the same conduct. And so that's somewhat changed the analysis, because again, by bringing these provisions in, the legislature is providing more legislative intent of when multiple punishments can be imposed. In other words, more than one crime for the same conduct. And
Okay,
limited
so I want to be able to get a handle on this. So the first issue is the multiplicitous convictions, right? That's your first argument. So when we start with multiplicitous convictions, then what we're saying is that, we go to, we have this analysis and say, do they arise from the same conduct? By statutory definition, there is one offense. And then we consider if it's a single statute or multiple statutes. Here we have multiple statutes. And so we employ the same elements test under Blockberger, right?
That's the Schoonover test under the old version of the statute when you only had the subsection B. That test was developed before the legislature added in these additional 2 subsections.
Okay, so we don't use the same elements test.
I'm not saying not to use it. I'm just saying that there's not case law that directly says it applies. So Schoonover was applying that to with the subsection that says all elements are identical to some elements of the greater crime. And talking about Schoonover was identifying when the offenses were identical would be on the same elements test. Although there's also case law that says that you have to look at the offense that's being prosecuted. So you don't look at all elements of the crimes and comparing them. You look at the elements that are actually charged, because some crimes have different ways of committing the crime. So you look at the facts of the case and what are the elements of the crimes that the state was alleging. And then you look at those elements.
Okay, so when we're looking at those elements,
But our argument's under subsection E, which is the new statute that's come in that says not convicted of identical offenses based on the same conduct. And I'm not necessarily arguing to you that you shouldn't apply the same sort of tests that you've developed in determining whether they're identical. But I'm just pointing out that there's no law either way on those new subsections about what
identical offenses
analysis
based
you
on the
apply.
same conduct.
Right. And we had the
But
identical.
do I
I'm
understand
sorry.
you to say that the elements test could fit there? I mean, that identical offense could be same elements.
It could be. We had the identical offense doctrine for years, and it's based on due process. And basically it's saying if you're a defendant and you're saying, I'm going to do this conduct and this is the crime I'm going to be convicted of and this is the penalty I'm looking at. So if you have 2 statutes and they both cover the conduct, they're identical offenses, under due process, the defendant should be sentenced to the more lenient penalty provision. So that's the doctrine that this court applied for years and using the law that I talked about. And now the legislature's brought this in. But the legislature says the state gets to choose. So if you look at the statute, it says the state can choose. You can't convict of identical offenses based on the same conduct, so the state can choose which one. It's not both. And that conflicts with the identical offense doctrine that this court applied for years.
Don't you to win have to get to a factual comparison? Because the elements of conspiracy are different than the elements of murder, even with aiding and abetting. It just happens that here, the Aiding and Abetting Act was, the Conspiratorial Act, I guess, also resulted in a murder. But the conspiracy statute doesn't require that murder. It just requires
Yeah, an overt act.
overt act.
Okay, and my brief took exception, I still take exception with it's the Mincy case from 1998 that says they're different because aiding and abetting requires actual participation. And I disagree with that because you can procure, obviously there wasn't direct participation here or actual participation. So I don't think that's correct. To me, it's kind of like the capital murder case.
Let me interrupt very quickly. So under the facts, we did have evidence that he made a phone call, that the defendant in this case made a phone call and directly assisted in committing the murder by telling James, that's how I called him in here, where the victim was.
Yeah.
The victim was in the driveway. And so then they went to the driveway that was next door. And then they said, okay, well, now he's left. And here's the route he took when he left. I mean, that's pretty much participation.
Right, but there wasn't direct evidence of that. So for example, the phone record showed a phone call had been made, right? At the time that, but it didn't give us the contents of the call. At the time that Payne, the deceased, left, the woman and the man who also could have, who was her, I'm gonna have to, the man who was the other person who was involved with the woman, okay? So the man and the woman come in the house, it's the other man who's on the phone, it's Clayton who's on the phone, it's not Mr. Alston. Clayton's agitated and Clayton's talking to somebody on the phone. That was a defense that Clayton could have been the one doing everything you said. Mr. Alston was standing at the window. He wasn't on the phone. And he said to somebody, oh, he's leaving now. But Morrison, the woman, didn't know who he was talking to. She just heard him say out loud. So I think when you're talking about a phone, you're referring to the fact that Morrison claims that she later saw a text on Mr. Alston's phone that said, job done.
But what about the thing that said, I'm gonna, not job done, but my guy gets the job done, or, you know.
That was a friend of Morrison's or an acquaintance of Morrison who testified to the next day after the shooting, that asked Mr. Alston if he was involved in it.
No. This is before, when they were making the plans. And he said, my guy
Oh,
gets
and I
the
walked
job
up the
done.
stairs. So then I'll walk up the stairs, so
Right,
three of them. Now I
right.
walk upstairs, my boys get things done, right?
Right.
That's it. That's the evidence. This is all very circumstantial.
But so what? It's circumstantial.
But
I
it
mean,
does-
this is participation.
Right, but it doesn't really change the analysis because we don't know which theory the jury went with. We don't know if the jury said, we're convicting him of aiding and abetting because he procured, or we're convicting him of aiding and abetting because he aided, right? We don't know, because the verdict doesn't require us to, it doesn't require them to say, right? This is all just instructed, one instruction.
But we
So
do know that there were two separate counts and that they convicted him of the aiding and abetting and the conspiracy.
But it's all based on the same thing. I mean, based on the state's
They have
argument.
different elements.
Well, they don't. If you look at, if you say, in order to procure, you need an agreement. If you have a group effort, for aiding and abetting, you've got to have a group effort, right? In order to have a group effort, you've got to have, I mean, it's an agreement. Yeah, if you ask somebody to commit a crime and they say, yes, I will, that's an agreement, right?
Right, but one is asking, okay, let me look at what we have here. One is asking, and the other is agreeing, okay, I'm part of the team. Advising, hiring, counseling, or procuring is different than, yeah, let's go get him, being part of the huddle. Being part of the huddle, is a conspiracy, but procuring, now I lost it again.
I understand what you're saying, but
Yeah.
the way in our case law, agreement can be inferred from the circumstance. Doesn't have to be like, oh, I'm agreeing to do this with you. A jury's told they can just infer there was an agreement. So if people act together, you can infer an agreement from their acting together. I mean, it's.
Along those lines, isn't there a more fundamental problem, it seems to me, with your argument, which is that aiding and abetting is not a crime, and it's a theory of vicarious liability. And doesn't
Right.
that, I mean, so how
Well,
How
it's
do we
not-
have any identical offense?
It's not a crime. We don't this court has not, in the past, has not labeled it as a crime because the state doesn't charge it. And so that's why it's not. But
But it's-
jury's got to make the findings. I mean, I don't know what you want to call it. It's part of the offense.
Right, but if we look at legislative intent, I mean, the intent of the conspiracy crime is to punish the agreement.
Mhm.
That is the crime, is the
Mhm.
agreement.
Right.
The reason we punish homicides is because it's a killing of another person. And those are two very different crimes.
But the state obtained its conspiracy conviction based on the commission of the completed crime. That's the only overt act they alleged. They didn't have to prove any other overt act. It's not just an agreement to get a conspiracy. You got to have an overt act.
Right.
And the only overt act that the state
And you're
proved
just saying
was a completed crime.
that you don't
So-
think the legislature intended to punish those as two separate crimes?
No,
Agreement and then the completed crime.
how do you know that they intended? I mean, there's some states where by statute, how do you know that they intended? That's what we're trying to discern, right? You're assuming they intended. There's also an argument to be made that they intended a conspiracy but the completed crime is not committed. And so they only they need to have something that falls short. When you don't have the completed crime, we still need to punish the attempt. We need to punish the solicitation. We need to punish the conspiracy. And that's what it's for. It's really saying if you take some initial steps towards this, but you stop or it doesn't get done, you're still culpable.
Sure.
Yeah. So I mean, that could just as much be the legislative intent.
As you pointed out at the trial court level, the general specific was the focus. Are you abandoning that on the people?
No, it was one of the arguments. And again, I'm not abandoning it. I think it's a harder argument to make. Probably would only echo counsel's comments about it being more specific because this was the specific conduct that the state alleged was the conspiracy. And then the state said, through the conspiracy, he procured these men to do this, and that's why he's guilty of premeditated murder. And so counsel argued below that the conspiracy was more specific because it covered the agreement and the completed crime. But, you know, I see them as being identical the way, so I think that's a little bit tougher argument to make. But it's harder argument to make than other cases this court has had dealing with specific in general. But I mean, it's true. I mean, basically the state's theory of this case was a conspiracy. I mean, counsel's not wrong about that.
And if you were to prevail here, one outcome would be that you simply could never convict somebody in a straight murder for hire scheme of conspiracy and murder.
If you allege a different overt act.
Why does that matter?
Well, because then you have to prove an actual conspiracy. I mean, the state had trouble.
And let's say we have a written contract.
You got the agreement, but the state, for example, proving what was the overt act short of the completed crime here, right? So maybe an overt act could have been, you know,
you
what the
think
justice has suggested that he conveyed the guy's leaving now.
The state's selection of the overt act changes whether it's an identical.
Yeah, because once you charge the completed crime as the overt act, you're always going to get a conspiracy conviction. They should have to prove something separate from that.
Other than the completed offense.
Right.
Yeah.
I'm out of time. My microphone issues, so I think I'll sit down unless there are questions.
Good morning, may it please the court. Again, the state appears by Deputy District Attorney Jody Lipton. If we're just going to focus on issue 1, the state's position here is that the aiding and abetting theory and the aiding and abetting premeditated murder here and the conspiracy to commit premeditated murder are not multiplicitous. Our brief outlined the same elements test. And I guess I didn't see any other tests being offered by the defendant, so we went with the Schoonover test, and I think that's how it was argued below. Also, in the motion to dismiss, And
But what do you
then-
think about opposing counsel's, I guess, submission that in order for it not to be multiplicitous, you have to allege a different overt act besides the completed crime?
And I guess I didn't pick up on that in the brief, but I guess I would say that doesn't matter. I mean, if the elements are different, then
Well, would you have had a conspiracy if the murder wasn't committed under your theory?
you still have an agreement, and I think the agreement is the focus.
But what would have been the overt act?
It could have been the phone call he made saying,
But was that, she said that wasn't, he wasn't on the phone saying that. I don't remember the facts that detailed. He was at the window. I thought he was on the phone saying that, but she said he was at the window and somebody else was on the phone.
my recollection is that Mr. Alston was at the window, Mr. Clayton was on the phone.
Right.
I think,
I
Who's the
do
other
remember
man?
that, right.
and he was saying how this had him messed up. He was upset. Something had him messed, his comment, Mr. Clayton's comment was, this has got me, effed up.
Right.
And then Mr. Alston was saying he's leaving now, and Miss Morrison just hears him say that. She doesn't know who he's saying it to. But I think the inference is,
But he's not on the
Clayton's on the
phone.
phone.
He's not on the phone.
that's my understanding, but I think the inference is.
And how could
Clayton's
that
on the-
be, how could that be an overt act then?
He's still giving the direction
To who?
to Clayton, who's on the phone with presumably James Boatwright.
What was that communicated?
I think the inference is there based on, we have the phone records of all of the phone calls between the three and the text messages. So yes, I think so. But just looking at this from a same elements test, the elements are different. So I don't think we need to get into the facts of which one. As far as
Well,
procuring.
opposing counsel argued that the elements aren't different because if the state chooses an aiding and abetting theory, which relies on an agreement, and now their elements are the same. How do you respond to that?
And I guess it's not I guess I don't know where the agreement is coming in from the aiding and abetting. Procuring is agreeing.
That's how I understood.
Yeah, I guess I would
opposing
just-
counsel's argument.
I guess I would disagree with procuring is agreeing. Procuring is separate from an agreement.
What if it was a murder for hire and you had a written contract? That's procuring and it's an agreement.
I hadn't really thought about that. I mean, I guess it would be, but I don't know that you have to. I mean, I'm not sure if that makes it just the element of the crime in procuring.
How many written contracts are there?
Yeah, I mean, I guess I don't have a better answer than that, Your Honor, just that,
But just to sort of explore defense's argument to its full, it does strike me that there's something there. I don't know if the elements are identical, but it does seem difficult to think of a procurement that does not involve an agreement. If you, let's put it this way, let's just say there was procurement and the state charges conspiracy. I mean, you're going to have all kinds of evidence of an agreement.
right. I mean, I guess that goes into, and aren't we really? This is a theory of premeditated first degree murder. So you're looking at the elements of, if we're looking at the instruction and the elements of murder, the aiding and abetting theory is, yes, that's what we have to prove, but it's not in the actual instruction, I guess. So we're looking at the elements of the crime from that.
Yeah, so your
standpoint.
argument goes to my earlier question, which is, look, this is a burden of proof, but it's not an element of the crime.
Right.
And conspiracy doesn't involve, in this case, for the murder, aiding and abetting, you had to show premeditation, right?
Correct.
And in the conspiracy, even though the overt act was the killing, there's no premeditation required in the conspiracy?
Yeah. I'd have to look at the conspiracy instruction, but it's the agreement really. is the focus of the conspiracy is what I understand.
So there
But-
would be no premeditation required.
Yeah. Well, he agreed with others to commit murder in the first degree is the first element. And did so with the intent that the murder in the first degree be committed. So,
But the mention of premeditation is not in there.
I mean, well, it's set out in the definition of murder in the.
Yeah, you have to have the same,
the-
you have to have the same state of mind as the,
Well, under
goes
the
back-
aiding and abetting, but I didn't know under the conspiracy.
It references the murder in the first degree instruction
Okay.
too. Yeah, back in.
So who has to perform the overt act? Does it have to be the defendant, or can it be person, James, who's driving over to?
I think the statute says it has to be proved by such person or a co-conspirator.
Either one.
I believe that's what the statute says. Back to my notes. I don't know if I want to get into the second issue unless the court has any questions on it. It was just about the district court abusing its discretion when it denied the defendant's motion for new trial. We would just ask this court to affirm the denial of the motion for new trial based on the improper admission of the evidence and the prosecutorial error claims that were made there. We would argue that the state did not, or I'm sorry, the district court did not. There was no error of law, no error of fact, and the decision by the district court was not unreasonable in denying that motion for new trial. Further questions? I don't have any more presentation.
I think on the question about aiding and abetting isn't an element. It's part of the offense that the legislature has said the state has to prove in order to convict. So to me, that's what that's the concern here is what is the offense? How does the legislature define the offense? And it's there in the statute. The person is criminally liable for a crime committed by the other if the person does X, Y, and Z. So that's how the legislature has defined the offense. And that's what governs. On the overt act and furtherance of the agreement, to me, it's kind of like the capital murder cases where for capital murder, it's an intentional premeditated killing done in the commission of rape. And then this court has said, therefore, you can't also convict of rape. That would be multiplicitous. So it's like that. And it's the same thing with the aiding and abetting. You're adding in something, you know, intentional premeditated killing and you procured somebody to do it. You have to add in something else. And when you add that in, that's where the multiplicity comes in. And when they added into the conspiracy that you had the agreement and one of the conspirators committed the killing, you're adding that in. That's what the state's choosing to do. They're choosing to add that in as their overt act.
In 2014, in the Betancourt case, we said aiding and abetting does not add statutory elements that the state's required to prove. And then in Robinson in 2012, we say aiding and abetting statute shows it's an assignment. This is what Justice Stiegel said. It's an assignment of criminal liability rather than creation of a distinct element of a crime. Extends criminal liability.
Right, again, but it's something the state has to prove. It's the defining of the offense that the state has to prove in order to get a conviction. If you don't want to call it an element, that's fine. It has a mental state, it has an act, which are things we usually think of as elements. But again, it's semantics. It's something the state has to prove, and that's what matters.
And it was incorporated into the elements instruction, right, for first degree murder with the or another language, or was that?
It's actually instructed separately. And it's
Correct, but the
basically- yeah.
hook to get to that separate instruction is the or another language in the elements instruction for, or was that not included?
Sometimes courts will say, you know, Joe or another person who, you know, Joe is criminally responsible for.
Right.
Sometimes they'll say that. Sometimes they'll just say Joe, and then they'll say, you know, Joe's responsible for what Sue did.
That's why, I guess, do you recall from the instructions here, which version was used?
They just did a straight up that the instruction read that Mr. Alston the defendant committed a intentional killing and that it was done with premeditation. Obviously, since Mr. Alston, yeah, the only way you could find that from the evidence is if you then go back to the instruction that says you're liable if you procure somebody else to commit a crime, then you're also liable for the crime that's committed.
If you prevail on your multiplicity argument, what are you asking for?
Well, we're asking for the court to only enter a conviction for the conspiracy charge. The statute says that with identical offenses based on the same conduct, the state can choose which one to enter a conviction on. But under this court's identical offense doctrine, under due process considerations, a court can only convict of the lesser. So the statute conflicts with this court's rule, which is based on constitutional considerations. So obviously, we believe that the constitutional consideration of due process
So
outweighs the statutory.
would we have
qualifier.
to find that statute unconstitutional to get to that outcome?
Well, the part about the state getting to choose, that's the part that, just that part, not the rest of it.
Just that part.
Just the part about the state choosing, because this court, in your case law, based on due process, the defendant gets the benefit. When you have two, statutes that cover the same conduct, they get the benefit, they get the lower penalty. That concludes my comments. Thank you.
Thank you. The court will take this case under advisement. The court is in recess until 10:45.